Oh, God. The government of Jamaica wishes to provide clarity on the selection process following recent inquiries. And the clarity they said they were trying to provide, it was so opaque. It was so ridiculous. They literally withdrew this press release. But how can you withdraw something that is actually out there? And it makes no sense, and it raises more questions than answers. Because the qualifications that they've put into this document is completely different from what was actually advertised. Yeah? So, I'll come back to this soon. Because this is not looking good. The front page of the Gleaner this morning. Where's my paper? Dangerous conclusion. Data privacy expert slams Supreme Court's quote dramatically erroneous stance, end quote, on financial institutions giving MPs information to the Integrity Commission. I'm joining attorney at law Chuck Cameron to talk some more about his review of this decision, parts of which I read to you last week on this program and took some time to read some portions because of what is contained in the decision as well. It is in the matter of the Integrity Commission Act and in the matter of Section 7 of the Integrity Commission Act. It's a matter in which the Integrity Commission sought an order from the court to compel a couple financial institutions to disclose information on various politicians. And when the financial institutions refused and said, perhaps you need to go to court because of our concerns about secrecy under the Banking Services Act and so forth, they filed the papers in court, and the court ordered that these financial institutions, as well as the Attorney General, be served with the application by the Integrity Commission. The Attorney General's office was invited to make submissions, and I read through some of the conclusions of the learned judge because of just how it was actually stated. I'm joining Chuck Cameron now, though. Good morning, Mr. Cameron.
Good morning, Emily, and your listeners. How are you doing?
Very good, thank you, and good to have you.
Yes, please.
Have you seen the front page of the Gleaner this morning?
Yes, and I saw it, and I saw myself, and I was shocked when I saw it. But yes, I did see it. Thank you.
And the reason for your shock is?
I don't usually see myself on the front page of the Gleaner.
Well, you look lovely, if that's your concern. Yes.
Thank you very much.
But the sentiments in it, you have an issue with the sentiments quoted?
A big issue, because exactly what you said is exactly what did not happen, Emily. I'm going to invite you to pick up the decision again. The Integrity Commission did not obtain a court order compelling any bank to disclose information. The Integrity was not conducting an investigation. This is where the Director of Information received statutory declarations, and the Director of Information wanted to verify the information. And what did they do? They wrote a letter saying, hey, give me all of the information on this public officer
on these individuals, and I understand it was over 100 and odd individuals.
This is in relation to the case, the decision.
Yes, yes.
Right.
That's what happened. So on paragraph 12, let me just come in a second. Please. At paragraph 12 of the decision, the court puts the request for information, which was made by the Director of Information and Complaints. Yes. And it says, having regard to the foregoing, the Integrity Commission, pursuant to Section 7, various 7s of the Integrity Commission Act, hereby request information with respect to the attached list of public officials who file statutory declarations with the Commission, their spouses and children. Should these individuals maintain an account or accounts with your financial institution or its subsidiary, directly or by virtue of association with a company, trust, or otherwise, the Commission requires your cooperation to provide the following information. 1. Bank balances on bank accounts and other financial investments as at December 31 of each year for the period January 31, 2016 to 31 December 2019. And dates on which the account or accounts were opened and their status. And
Thank
your
you.
response is required. Yes, go ahead and complete. Yes.
So no investigation. People submitted their statutory declarations because the law said that they must, and if you don't, it's a criminal offense. And persons have been criminally prosecuted for not filing a statutory declarations. So they just simply write a letter and say, you have a duty to cooperate with me.
Mm-hmm.
I'm not conducting an investigation, but just give me all the information you have, exactly what you just read.
Mm-hmm.
Emily, that is, in my mind, worse than what Elon Musk sought to do with Doge. Going to all, because this is a court sanctioning that you can just write a letter and demand that you get all the information on an individual. But let us not confuse your listeners. I am of the view that the Integrity Commission must have far-reaching investigatory powers to investigate, investigate where they are of the view that there may be some corruption, because corruption is rampant in Jamaica, and that is timing our growth. Need to be very clear about that. The problem is they saw nothing that rose to the level of an investigation, because Integrity Commission has a director of investigations.
Mm-hmm.
The director of investigations, exactly like what you said, Emily, exactly like what you said at the top of this segment. They can go to court, tell the court what they need, what their reasonable suspicion is, and get an order to compel the bank to produce the information. That did not happen in this situation, and therein lies the serious problem.
Right.
Emily.
So am I understanding you correctly? Do you have an issue with the article as written, or you have an issue with the decision of the court?
The decision of the court.
Okay.
No, the decision of the court.
Okay.
The decision of the court.
Right. And before I go further, I lamented here last week, Mr. Chuck, Mr. Cameron. Have you seen that the let me see. The Attorney General filed submissions which generally supported the Commission's application?
That's, you're giving, as you say that, I'm getting goosebumps, Emily, because as I understood it, the Attorney General is there primarily to defend and uphold the Constitution, then the laws of the land. But what has happened, it has now been flipped on its head. There's a deeper problem, Emily. We have an information commissioner who is supposed to defend the right of the citizens to informational privacy, and a very robust legislation. But that information commissioner's powers has not yet been enacted. So the citizen, me, and you are now left exposed. And it's not only the Integrity Commission, Emily, if you are to follow this through logically, because remember, they are not exercising any statutory investigatory power. The power, what lawful mandate or activity has been doing verifying information. So it follows that any public institution that is seeking to verify information that you have submitted can write a letter to any entity, with the exception of a law firm, and say, give me all the information you have on this person and all of their family members. And that letter has the force of law.
Well,
as a result of this decision.
I don't know if I would agree on that point.
Why not, Emily?
Because, because it seems to me, as much as I take a serious issue with Section 7 of the Integrity Commission Act, and its width in light of not only data protection but privacy issues, it seems to me that the reason the Integrity Commission and the Integrity Commission alone can do what the judge in this matter says that it can do, whether it's a director of information or complaints or a director of investigation. The reason that can be done is because of Section 7 of the Integrity Commission Act. And that says the commission may, in the performance of its functions, work in cooperation with any person or body as it may deem appropriate. Then at 2, a person or body shall cooperate with the commission in the exercise of the function conferred on the commission under this act or any other enactment. In other words, it seems to me that there is a statutory compulsion on a person or third-party entities to cooperate with the commission in the performance of the Integrity Commission's functions, and I don't know that we can stretch other requests for information where there's not the statutory mandate.
So, while this is a red herring because we agree on the substantial issue,
yes,
I'm still going to engage on it and say there is a common law duty to cooperate with all investigations of that nature. And you are then put on the back foot because there is a common law duty to cooperate, Emily.
Yes.
Not because it hasn't been hard-coded. So what I've said, if we accept that our common law imposes that obligation, it is not an impossibility, but that is a red herring.
Yes, yes. So your chief contention is the Director of Information and Complaints under the Integrity Commission Act.
Not conducting an investigation.
Which he does not, because it's the Director of Investigation that
Correct.
conducts an investigation, yes?
Correct. By way of letter, is now in a position to compel any third party to produce all the information they have on them and their family, with the exception of an attorney.
Mm-hmm.
How does legal professional privilege take precedence over the right to informational privacy and the right to privacy? How does that take precedence over contractual obligations? Where is the logic? So the logic behind the judge's decision or the court's decision was that the public officials, by filing their statutory declaration, gave implicit consent to their information being accessed.
Yes.
Because what the right to informational privacy says is that no one shall use your data or my data without my authorization. The judge made short shrift of it by saying, he implied.
But not only that it is implied, he's saying that the constitutional issue, the matter of informational privacy, which the Chief Justice spoke at length about in Julian Robinson, he said that it can be distinguished.
Doesn't arise.
Yes.
And the right wasn't engaged. And that is where our court, in more than one decision, because that was the same issue in the Amar Leon issue constitutional decision, Emily.
Which you dealt with, yes? What did the court say?
Not appreciating when the right to informational privacy has been engaged. Once you are attempting to use it any at all without consent, it has been engaged, and it's now left upon the state to say that, no, we have a lawful basis to do so. What this court said in this situation was that he gave consent, so we don't have to test whether or not it is necessary, proportionate, or in accordance with the law, or demonstrably justified. If it is, I'm compelled under pain of prosecution, how can that be viewed as consent? Consent must be voluntary.
Right, but what about 7.4 of the Integrity Commission Act, which I think is so crucial? Any information or document disclosed by a person or body under subsection 3, which is where the court grants the application, without notice, they can go without notice, but in this case we know the court ordered for the parties to be served and the AG. But where any information is disclosed by a person or body, that shall not be used in any criminal proceedings against such person or body, save and except in criminal proceedings for the offense relating to the provision of false or misleading information. In other words, listeners, if the Integrity Commission goes to any financial institution, let's say the Director of Information and Complaint goes and requests documents, and they feel compelled by this decision to turn over the documents to the Director of Information and Complaints, the Director of Information and Complaints cannot use that information for anything criminally incriminating against that individual. Is that not a protection against sort of self-incrimination, for want of a better way, Mr. Cameron?
So I am speaking from the position that we have a right to informational privacy. Whether or not there's protection down the road is another question. The first question is, do you have any right to access it, any at all? Tell me, Emily, that the Information Commissioner is a registered data controller and they have robust data protection and information security systems built in. So what happened to Financial Services Commission and what has happened to several government and private entities doesn't happen to them. So what if there's that line in the law? They have no access to my information. If it is, I went to a clinic that is known to treat STDs, and the Director of Information now has my credit card bills. He now knows by mere association of me going to the specific medical provider that I may well have AIDS. That there is by me knowing that somebody knows that, and that's something I've tried to keep secret all my life, I am suffering damage. So whether or not they can't use it to prosecute me is of no moment. And that is another red herring.
So is it that you believe, because of the importance of informational privacy as a constitutional right, which the court read based on the Julian Robinson matter, are you also saying that the Data Protection Act, that portions of it have perhaps impliedly repealed sections of this Integrity Commission Act?
It's not the Data Protection Act. Remember, the state shall pass no law that abrogates from a charter right. So the question is, with the interpretation that's been handed down, does that section now abrogate the the right to informational privacy right that has been guaranteed by the charter? One legislation can't repeal another. The question is that section, given the interpretation of the Supreme Court, is that section now unconstitutional? That's the question, Emily.
But didn't they learned judge Even though you may disagree with his view, he addressed his mind to the constitutionality of it. But he seemed to have formed the view, one, not only that it doesn't arise, but if it does arise, it seems to be demonstrably justifiable because of, as he says at paragraph 58, the pursuit and the realization of the objectives of the act are of fundamental importance to the welfare, order, and good governance. It is a matter of public notoriety. That's corruption is endemic in Jamaica.
Let's go down that road, Emily.
Yes.
Let me go down that road. I laughed because it is laughable, but let us go down that road. What our Constitution says, when seeking to restrict any right, you must use the least intrusive method, or it must be proportionate. So if it is in the same legislation, you have the tools available to you to achieve the same objective. You can achieve that mandate and that lofty ideal situation. So you don't need to restrict to all Jamaican citizens' rights without any due process or without any judicial intervention, because you already have the mechanisms and the tool in the same legislation to achieve your objective, Emily.
What are the tools that are there?
Go to court and get an order to produce. Simple. That's what the law provides for.
But why should they have to go to court when Section 2 compels, by the use of the word shall, to cooperate with the commission?
And that is why it is now, the question now is, it goes back to the same thing, whether or not that now abrogates our right to informational privacy. And the reason why, Emily, is because when you're restricting someone's rights, it must be a balancing act. It must be, you have to weigh the right of the citizen against the right or the objective of the state. And in order for to maintain our democracy, there must be an impartial, independent third party to determine whether or where that balance must lie. That is why no letter from any bureaucrat can strip me or you of our informational privacy rights. This is what is called due process and the rule of law. It is as simple and fundamental as that.
And the remedy for this, you say, in your view, is what? How do we fix this statutory compulsion?
What is ideal is that the Information Commissioner, although her powers have not been enacted, that doesn't prevent her to intervene in this matter and seek a declaration and an understanding, because she has the remit to implement and oversee this legislation. So that would be the ideal situation. Will she step up to the plate? The other thing that can happen is that the affected public officials could also challenge this.
When though, Mr. Cameron, in this political season?
And that is one reason why they will not do it either, because it is a political motivation, and who hiding it and who are victimized. That is why I'm so impassioned about this, Emily, because of all of those issues that people can't get over.
I appreciate, but the Information Commissioner, does that office have a separate legal team apart from the AG's department representing it?
Well, the AG is an independent commissioner of parliament, so she couldn't even rely on the Attorney General. It's an independent commissioner of parliament.
So she probably has a full legal team there, yeah?
She has had attorneys. She does have attorneys working for her, and she can retain counsel.
Yes, because my worry coming out of this decision, as I said to you, counsel, is who is a possible appellant in this matter? There's none.
I am a possible appellant because I'm politically exposed.
But how can you appeal when you are not served with the papers? You were not an interested party at the hearing.
Our Civil Procedure Code provides for interveners by interested parties.
Yes, but at the trial stage, at the appellate stage, you can intervene.
I don't know. I don't remember. The Supreme Court still has. Let me use a layman. The Supreme Court still has jurisdiction of this matter, because if one were to file appeal, you have to go back to the Supreme Court first and seek leave. So the Supreme Court is still functus.
Well, I don't agree on that. But because, as you said,
you have to go to the Supreme Court first.
No, it's a final decision.
Oh yes.
So there's no need for permission.
I agree with you.
The Supreme Court is now functus, out of completely. So it would have to go to the appeal, and the Attorney General, having agreed with the arguments by the Integrity Commission, has relinquished all right. Never mind that the Solicitor General, when she appeared in the Parliament recently before the Joint Select Committee, she was arguing something completely different from the submissions that were made by counsel for the AG's chambers in this matter. So
that's the concern, Emily. It's not a good look, and it's not the first decision of this nature.
What do we do? At any rate, you lost in the Amoy Leon case, didn't you?
Because the court made up on the exact same point.
Yeah.
The right to privacy wasn't engaged.
Right.
What we have seen, Emily, is that the state always defers to the state. So if it is we have to be fighting crime, the citizen has no right. If it is a fight in corruption, the citizen has no right.
Well,
so much so that the president of the Court of Appeal at the opening of the session had to indicate that we now have to start paying deference to charter rights, because if cartel didn't go to the Privy Council, our court would have never recognized the right to a fair trial.
Let's come back to you. I'm out of time. I have to go to headlines. This is the hotline.
You're listening to Radio Jamaica 94 FM. The time is now 10 o'clock.
What? No. We kept, I certainly kept asking him questions as the issues arose in my head based on the things he said should have been done, or should be done, no, or are to be done, no. Why? You see, the issue is that, listeners, the perception is that, as the judge said, this is the perception we're up against, and when perceptions are the way they are, so much so that they can be stated as a matter of almost judicial note in a decision in the court. Never mind the absence of evidence, and the court is based on evidence. But if the perception is that the Integrity Commission Act is meant to cause thieving people to get locked up and forget people is one particular class of individuals we're talking about, then what now? Mr. Cameron, I thought I'd call you back. I really enjoy the conversation we're having, I must tell you.
Yes, please.
Yes, so what now, in light of the concerns you've raised and all of the thoughts coming to you as somebody who studied Data Protection Act and look at privacy issues under the Constitution in some detail, where do we go with this decision, particularly in this political season in which we found ourselves, and the perception which the judge has talked about with public corruption being endemic in Jamaica? What now?
So we do. I want to think I'm not a voice in the wilderness.
No.
Just yesterday, there was a 2-day privacy conference, and the theme was prioritizing privacy. What I would want to hope is that all privacy practitioners who I hope understand these issues, let their voice be heard. Mm-hmm. Because that legal solution, apart from the public official, the subject matter of this
request
challenging it, but I'm still exploring. If it is forget about the decision. Mm-hmm. Know that you're looking at the interpretation of that section. Mm-hmm. affected party can seek declaratory judgment on that.
Yeah, you don't need to be affected
Correct,
at all,
by the
but
decision itself.
but there's a possibility of your privacy rights, as set out in Julian Robinson, being
Correct.
infringed. So you can go to the court for declarations on this. Yes.
In the same manner that he did.
Yes.
In the same manner.
That's right. Because no right of his was infringed yet. But
Correct.
yes. Yes. So you might be an applicant. You may well. Or you,
So let's both of us do it together, Emily, because So this is a matter that the Bar Association
yes.
needs to take up, because in the GLC, in the Bar Association against the Attorney General,
Yes.
when the Royal Canadian Police Force went into lawyer's office,
Yes.
it was the same issue,
Yes.
But we weren't talking about a fundamental right. We're talking about the legal professional privilege, where
Yes.
lawyer is bound by his duty of confidentiality to the individual. Is this not a more important case?
Or equally
or
important.
issue?
Yes.
No, we're speaking about a constitutional right. It must be more important, Emily. It is not equally important. Yes, we do form part of we are a pillar of our democracy and how our justice system works, but a legal professional privilege does not equate to a charter right or a
Yes.
constitutional right.
Yes.
They are not on the same level. So I want to behoove the Bar Association to look at this matter closely. The Bankers Association, understanding that when we have our OAS obligations to ensure that there are no warrantless searches. This is what this is, This is a warrantless search.
I had a caller last week who aligned it with a search, and I said to him, it's absolutely not. It's not a search. It's a disclosure of information. He insisted it's a search. I don't have time to go into why you say it's a search, because I'm out of time and I have to take this segment. But thank you for your thoughts, Counsel. All the best to you, Mr. Chuck Cameron. When we come back, we have an interview. We're going to keep in company with the company's office.